Hello and welcome to today's event, Stamping Out Financial Discrimination, How New Legal Approaches Can Deliver Greater Accountability in the Student Loan Market and Beyond. To begin today's event, we will have opening remarks from Student Borrower Protection Center Executive Director, Seth Frodman. Seth?
Hi, everyone. I'm Seth Frodman, Executive Director of the Student Borrower Protection Center, and I wanted to take a second to thank you all for joining us this afternoon. I often open up these events by reminding folks of the sheer size of the student debt crisis. 45 million Americans collectively owing $1.7 trillion in student loan debt. But I think it is also critical to note that the student debt crisis is a civil rights crisis. Rigorous research over the last decade has shown that this crisis disproportionately impacts women and borrowers of color, especially those that are Black and Latino. Today's student debt crisis is a symptom of systemic barriers like racial discrimination and economic exclusion that hamstring borrowers from the start, and is accelerated by financial products and services that further drive disparities. And the discrimination and systemic inequalities that we see throughout the student loan market reverberate all across financial markets. In the financial services industry, the need for more rigorous discrimination enforcement is apparent. Today, we will not only hear a discussion about addressing discrimination across the entirety of the student loan market, but also how existing legal tools can be deployed to stamp out discrimination in other financial markets as well. Whether we're looking into predatory for-profit schools, unscrupulous debt collection practices, high-cost, high-risk private student loans, or dubious credit reporting models, there should be no doubt that discriminatory practices are illegal. We need regulatory and enforcement officials at both the federal and state level to exercise their full authority to protect consumers, which is why our conversation today is so important. We must do more than the status quo. Our system is broken. We can no longer allow student loan companies to run roughshod over borrowers. We can no longer ignore the role that discrimination in financial services play in denying equity and equality for communities of color. We must demand better. Today's panel builds off a recent article, Discrimination is Unfair, by one of our guests, Stephen Hayes, and his colleague, Callie Schellenberg. The authors of this article presented an important legal strategy on the use of Udap authority to address discrimination in consumer markets outside of just the traditional scope of the Equal Credit Opportunity Act. I'm honored to be joined today by our great panelists. These folks are legal experts who have been working at the forefront of consumer protection and civil rights, and we expect to have a robust dialogue. So with that, I'd like to once again thank you for all joining us today, and now I will turn it over to Sbpc's Director of Advocacy, Kat Welbeck.
Thanks, Seth. Good afternoon, everyone. I'm Kat Welbeck. I first just want to echo what Seth said and thank each of our panelists for joining us today. We're delighted for all of you all to be here, and we expect to have a really exciting discussion. And then also for those of you all participating in the audience today, we'll spend the majority of the panel discussing the legal theories laid out in Discrimination is Unfair. But if we have time, we'd love to take questions from the audience. So if you'd like to ask a question, just please feel free to drop it in the chat throughout the discussion. Or if you're on Facebook, drop the questions in the Facebook Live, and we'll do our best to get to those at the end. And so with that, I don't want to take any more time away from our panelists, so we're just going to jump right in. Ashok, Chris, and Steve, I'll ask each of you to briefly introduce yourselves, and then we can go ahead and get started with our questions. So Ashok, I'll start with you.
Hey everyone, my name is Ashok Chandran. I'm Assistant Counsel at the NAACP Legal Defense and Educational Fund. I'm excited to be a part of this conversation. My work at LDF focuses primarily on equal access to opportunities in the housing and credit marketplace for Black and Latinx borrowers, as well as all borrowers of color. The paper, I think, presents really interesting ideas, and I'm looking forward to this conversation.
Thanks, Ashok. And then Chris, can we turn to you?
Okay, thanks a lot. Hey, everybody, I'm Chris Willis. I'm the industry representative on this discussion. So I'm a partner at Ballard Spahr, and I co-lead our consumer financial services practice nationwide. As such, we represent industry side players throughout the consumer financial services industry, including student lenders and student servicers, but also, large banks, credit reporting agencies, and all the other members of the ecosystem. And I was lucky enough to be picked to speak on this panel because I wrote a blog about Stephen Cowley's article, which now I'm wondering if I should have done that or not. But I'm really looking forward to the discussion. So thank you to the Sbpc for having me on today.
Thanks so much, Chris. We're so excited to have you here. And then Steve, do you mind introducing yourself as well?
Sure. I'm Steve Hayes. I work at a civil rights law firm called Relman Colfax, and we do enforcement civil rights work, a lot of fair housing and fair lending cases on the plaintiff side. We also provide legal counsel to entities too, that is best practice civil rights, fair lending, fair housing advice as well. And I want to thank you for inviting us, but also thank Callie, who couldn't be here, for her work on the article as well.
Awesome. And thanks again for all of you all. And just to get started with a bit of framing for the discussion, Steve, I'm going to turn right back to you as one of the authors for the paper. Could you walk us through the article and the Udap discrimination theory that it poses? And then as you answer that more specifically, why do you think it's critical to make headway on addressing discrimination in financial markets?
Sure. Yeah. So I will, if folks can bear with me a little bit, I'll spend a little bit of time walking through the article, the importance of it, what the import would be, and then also maybe the likelihood of this theory actually going anywhere. But essentially, the article explores the theory of that discrimination is a type of unfair practice covered by state and federal Udap laws, which are laws that prohibit unfair, deceptive, abusive acts and practices. And the import is that anti-discrimination principles would uniformly apply wherever the FTC and the CFPB have jurisdiction, or where state Udap laws apply, which is frankly like a pretty broad swath of conduct. So existing anti-discrimination law now is somewhat of a patchwork with overlapping and some significant gaps. So financial regulatory agencies focus on the Equal Credit Opportunity Act and credit discrimination. Some of them focus on the Fair Housing Act, but those statutes generally don't cover other consumer financial products and services like checking accounts or consumer reporting agencies, third-party debt collection. And even where credit is obviously involved, some ambiguity can exist. So who qualifies as an applicant or a creditor covered by a COA? There's always some ambiguity there, which leaves gaps. And in the article, we talk about some specific student lending style or student financing related gaps. And the upshot is that of the theory, there's a large swath of transactions for which there hasn't historically been clear anti-discrimination coverage or agency jurisdiction, but under Udap there would be. And so really the theory isn't new. Commissioner Rohit Chopra, when he was, or still is, but in his role as an FTC commissioner, articulated it at least twice publicly last year. And of course, he's likely to be the next director of the CFPB. And actually the OTS of all agencies, which no longer exists anymore, articulated a variation of this theory in an old exam manual years ago, which eventually got dropped when the OTS was abolished and the guidance was rescinded. But the idea is the basic concept's been kind of kicking around for a while. And the legal theory really is, I think, relatively straightforward. So the act prohibits unfair acts or practices, and that term is essentially synonymous with discrimination in anti-discrimination case law and in ordinary parlance. I think you'd be hard pressed to find someone who would say that discriminating against women or Black consumers isn't unfair. One level deeper, there are 3 statutory requirements for something to be unfair, which is that it has to be likely to cause substantial injury to consumers. That injury can't be reasonably avoidable, and it can't be outweighed by countervailing benefits to consumers or competition. And so we can talk about each one of those prongs, but Commissioner Chopra says it's 3 for 3 in many cases. And I think that that's probably right. It's hard to argue with that. There's a more interesting question, I think, about disparate impact and whether the law would also be interpreted to prohibit disparate impact. In my view, there's a very strong case for that, actually, based on existing Supreme Court case law, which again, I can talk about how we get there. But I think once you accept that it can be a discrimination statute, the argument under Supreme Court case law for it also covering disparate impacts is actually quite strong. So then I'll end with a few thoughts on the likelihood of this actually going anywhere and what that means. Racial justice and equity are a huge priority for the administration, for the CFPB, for the FTC, and we've heard repeated references, especially from the CFPB, about looking beyond traditional fair lending tools to rectify these concerns. And at least in my experience, Commissioner Chopra is, he's bold and he's willing to take risks. I think he's very strategic, but if there's a moment for this theory, frankly, I think it's now. And then we can talk about what does it mean for the agency to actually pursue it, but it could mean an enforcement action. It could mean some form of informal formal guidance, or even a formal notice and comment rulemaking. Each one of those has pros and cons, and I think some of them are more likely than others, but there's a lot of flexibility there to pursue this theory in some way. So I'll stop there, but that's the upshot of the theory, and thanks for bearing with me on the overview. I'm looking forward to talking more about it.
That was great. That was great, Stephen. I really appreciate giving the audience more perspective on the article, and just circling back to what you were saying earlier about a lot of the article is student loan specific, and for those participating, and obviously for our panelists, here at the Sbpc, we focus heavily on disparities in the student loan market. So whether we're talking about debt collection practices that disproportionately affect communities of color, or disparate servicing outcomes, or even for-profit colleges targeting Black and Latino students. I know it's another paper that Steve wrote, but one thing is that while discrimination is unfair, talks a lot about discrimination in the student loan market through Udap laws. It also speaks, like you're saying, Steve, to how there's broader applicability through other consumer finance markets. And so, Ashok, I'm going to turn to you here. And with your experience in fair housing and civil rights litigation more broadly, could you provide some perspective on how this theory could be applied across markets, or in your experience?
Sure. So I think the theory of discrimination as an inherently unfair practice is a really fascinating one that would, while the paper focuses primarily on the Equal Credit Opportunity Act and more traditional credit marketplaces, I think would have significant ramifications for and impacts on other markets that rely on sort of consumer credit, including the housing market, because increasingly people rely on mortgage lending or other forms of credit products to access housing. And the FHA, while different in some meaningful ways from the Equal Credit Opportunity Act, does have some uncertainty associated with it now, because following the Supreme Court's decision in Inclusive Communities, which imported a requirement of robust causality in assessing a disparate impact claim under the Fair Housing Act, courts are struggling with defining the contours of that. And there's a little bit of uncertainty about and a little bit of difference between courts on what that requirement means. So I think in a world where the Fair Housing Act is currently being litigated and its bounds and its coverage are being contested, especially coming off of an administration that was promulgating regulations that would have narrowed or restricted the scope in other ways, I think the idea of using existing statutory frameworks to focus in on the fact of discrimination as an inherently unfair practice that disadvantages borrowers of color, potential homeowners of color, or renters of color, whatever the case may be, is a really interesting one. One of the factors in the paper that I thought was really compelling was how it conceptualized the use of Udap authority to broaden the coverage of our anti-discrimination framework. So the Fair Housing Act, for example, limits Section 3605, which is generally what covers the mortgage and lending world, to real estate related transactions, which I think refers to pretty much the making, purchasing, or providing of financial assistance in connection with housing. There is dispute, and courts have disagreed as to whether that covers sort of ancillary services, like I think the financial advisory services that are referenced in the paper. It's unclear whether, and courts have disagreed as to whether they're brought within the ambit of the Fair Housing Act prohibition on discriminatory lending practices. I think there's no question that under existing UDAP authority, those entities would be covered because it's a broader base of people who are defined as affecting interstate commerce, who would be regulated. And so given a lot of the uncertainties associated with and disagreements amongst courts in the context of the Fair Housing Act, I think Udap authority and existing federal and state laws that outlaw that, outlaw unfair practices, it's a really important opportunity, I think, to recenter and focus on the harms of discrimination.
Thanks, Ashok, and I really appreciate it. I feel like you and Steve did a really great job of really laying the groundwork for the theory and how in practice it can broaden anti-discrimination framework. And Chris, I'm going to turn to you because I think you might have a slightly different perspective. You mentioned earlier in your introduction that when the paper was released, you wrote a response countering the notion of a Udap discrimination claim as a viable claim. So would love to hear you elaborate and tell us a little bit more about your perspective here.
Sure, thanks a lot. And thanks again for having me on the panel. And, I'm trying to approach this from a practical legal standpoint. I'm not addressing the policy issue of whether obviously discrimination is wrong and it's frequently illegal, nor do I take issue with the idea that we ought to address it as a society and that it's appropriate for regulators to address it. And I think they're going to be addressing it a lot over the next few years. But I feel like it's kind of a stretch to say that Udap laws that have been around for hundreds of years should be interpreted to encompass discrimination, either disparate treatment or impact. But before I start with that, I just want to compliment Steve and Callie on the article. It's a very well-written, interesting, creative article. It has a lot of appeal from a textual standpoint, as Steve just went through the elements of unfairness, the traditional elements that have been around for lots of years. It's hard to say, well, hey, this doesn't fall within that. I think there are a lot of things that are hard not to fall within the very broad definition of unfair under that statute as well. But the point is, kudos on the article. I thought it was really interesting and very creative. But let me tell you why I personally don't think it's that likely that this is going to take off running and have a lot of regulators and courts enforcing Udap laws to prohibit discrimination per se. The first thing is just, it seems very strange to me that Congress and all of these state legislatures were outlawing discrimination by enacting Udap statutes, which in some instances have been around for over 100 years, seemingly without knowing it and without ever using, discrimination as an example of what's prohibited by it. And then those same legislatures go back and enact a large number of specific anti-discrimination statutes, like Title VII or the Fair Housing Act or ECOA, Age Discrimination and Employment Act, Americans with Disabilities Act, and then state laws like the Unruh Civil Rights Act or New York Executive Law 296A. If we accept the premise of the article that discrimination is already illegal under Udap statutes, then it seems to me that Congress and all those state legislatures wasted a lot of time in enacting the Title VII and the other parts of the Civil Rights Act of 1964 and all these other statutes. And so we're not supposed to, I think, as a practical matter, render statutory enactments to be meaningless or surplusage. And it seems to me that saying that we have this all-encompassing anti-discrimination statute already sitting in Udap would have that effect. And it seems to sort of usurp the prerogative of the legislature to decide when to specifically make discrimination actionable. Legislatures chose to do it in certain instances like employment, housing, credit, public accommodation. And then in places like California, they chose to enact wide-ranging, non-limited anti-discrimination statutes like the Unruh Civil Rights Act. But it seems to me that an argument for a construction of a Udap statute basically takes that policy choice out of the hands of the legislature and puts it in a regulatory authority or a court. And I think they're unlikely to go along with that. And as a practical matter, I think the federal and state regulators have a lot of priorities related to anti-discrimination that they can very easily occupy themselves with for the next several 10 or however many years without having to come up with a new statute. They have the statutes that they're used to, that they know a lot about, that in some instances they spent decades building up law and regulatory precedent and expectations under, first with the federal banking regulators or HUD and now with the CFPB, that I don't think they need to be particularly adventurous with a legal theory to have lots of work to do that I think they will feel is very impactful and beneficial for consumers and will really move the needle from the standpoint of helping eradicate the impacts of discrimination in our society. So I don't think they will feel that there's a lot of gain in terms of using their Udap statutes in this way, but there's risk. And the risk comes from the fact that, based on my sort of read of the federal judiciary at the moment, is it doesn't look to me to be in a very receptive state to accept the argument that discrimination is actionable under Udap statutes. In fact, if I were on the consumer advocacy side right now, I'd be really worried that someone's going to take a case to the Supreme Court about whether disparate impact is actionable under the Equal Credit Opportunity Act, because the argument can definitely be made that it doesn't match up well with all the factors that have been used by the Supreme Court in Inclusive Communities, Smith versus City of Jackson, et cetera, to identify when a statute prohibits disparate impact. You can take them side by side and make that argument. And the current composition of the Supreme Court doesn't look to me to be that friendly to the argument of saying we'll be very expansive with disparate impact. So I would be worried about that from the consumer side now, and it would definitely make me reluctant to want to bring out a theory and make it subject to litigation in the federal court system that is as creative as this one. And so that's why I think that the risk reward from a regulator standpoint may not be there for them to want to adopt a theory like this. And then I would say on the disparate impact point, which Steve addressed just a minute ago, I think the argument gets stranger when you try to bring disparate impact under an unfairness sort of rubric. First of all, from a legal standpoint, we know in cases like Inclusive Communities and Smith that the Supreme Court says it's looking for certain magic words, certain specific language in a federal statute to provide the evidence of congressional intent to base legal liability on a violation of the law that's not intentional, but on the effects of a neutral, non-discriminatory practice on a protected group of people. And I just don't think the magic language that was found in Inclusive Communities and some of the other statutes is really present in these UDAP statutes. But moreover, the thing about UDAP statutes is most of them, leaving the one in Dodd-Frank aside, but if you think about the Federal Trade Commission Act or other more generalized UDAP statutes, they don't limit themselves to financial related transactions. So we can talk about debt collection and consumer reporting and checking accounts and things like that, because we're all familiar with those as consumer finance lawyers. But let's think about the fact of a UDAP statute like the Federal Trade Commission Act doesn't just apply to those things. And so do we really think that we're going to have a court or a regulator sign on to a position that requires disparate impact analysis by grocery stores or car manufacturers or publishers of magazines or manufacturers or sellers of sporting goods or basically every other business in the country? It seems like a very strange and kind of unrealistic result to me. But the problem is once you're relying on a generalized UDAP statute, again, not the Dodd-Frank one, because that is limited to consumer financial products and services, you've imposed that disparate impact sort of rubric on basically the entirety of the economy in a way that doesn't seem likely to me for a court or a regulator to accept. So I'll conclude my remarks by saying my hat's off to Steve and Callie for the creativity and the reasoning of the article. But I just think as a practical matter, I'm not thinking it's that likely that we're going to see a position being taken by a court or a regulator that goes along with it.
Thanks so much, Chris, for that perspective. And so one thing I want to do is I would love to hear Steve's response. Steve, I saw you nodding a little bit back and forth. I would love to hear your response to Chris, and then also Ashok, feel free to jump in if you have thoughts too as well.
Sure. And I will start off when we released the paper. Not long after, Chris had a very thoughtful blog post and we emailed back and forth about it. It has been fun to think through the problems because I think it's an interesting problem. And there are counter arguments to it. I would, to respond to them quickly, Chris made the good point that there does seem to be something a little bit strange about having specific statutes and then having some overlap with UDAP. But that's actually pretty common for UDAP laws. I mean, UDAP is oftentimes, and in fact, was designed to fill in some of those gaps. And so if we think about an example, the Fair Debt Collection Practices Act makes it illegal for debt collectors to engage in certain practices, but it only specifically applies to third-party debt collectors. And so you might think that those same practices wouldn't and shouldn't apply to first-party debt collectors, but the CFPB has taken the position that it does. It fills that gap, and this is really not very different. ACOA prohibits discrimination by creditors. UDAP would extend those protections to other entities. And as Chris said, for CFPB, it's easy to say financial institutions. It might get more complicated for other types of institutions like the clothes manufacturers of the world. I don't think, frankly, that's a good point analytically for sure. It's not that hard for an agency to cabin the type of action that it's bringing. And then also to say, I mean, one of the reasons that we have a public policy limitation in almost every UDAP statute for unfairness is there might be some circumstances where, frankly, this doesn't work. And that would be a great place for an agency to say, well, we apply it here. It makes a lot of sense for deposit products. It doesn't make sense in this other area. And so I think that you could limit that without much difficulty. For disparate impact, I agree too. I mean, to say that it covers disparate impact is more complicated. I think that the argument, and frankly, if you had a good disparate treatment case, if someone was actually discriminating against women in deposit products, and they were clearly intentionally doing that, I think your chance of winning before a court is quite high, actually. Once you accept that unfairness can be a discrimination statute, current Supreme Court law is for discrimination statutes, they must be construed to encompass disparate impact when the text refers to the consequences of actions and not just the mindset of the actors. And that's actually unfairness to a T. It's all about outcomes. And so at least under existing Supreme Court law, if you accept it's a discrimination statute, it's quite easy to get to it being a disparate impact statute, I think. Again, I mean, that's under existing Supreme Court law, which I think probably brings it to Chris's last point, which is there's some risk in pursuing something like that. I mean, I will say, what is really the risk? If it's a strong case, I think you've got a high likelihood of winning. If an agency did a rule and it lost, we're frankly in exactly the same place that we've been for years. So the risk doesn't seem so high to me, other than the resource loss that you have. I will also make the point, though, that I'm very sympathetic to this idea of the changing courts. Especially the Supreme Court now is a more conservative, and that's in our practice, our litigation practice, something we think about a lot to try to be strategic about the cases that we're bringing, how we're bringing it. I will also say that sometimes the intuition that a conservative court is not going to accept a consumer-friendly case can be wrong. And so I think back on Bostock from last summer, where this conservative Supreme Court held that the word sex in Title VII includes sexual orientation and gender identity. Despite very little evidence that that's actually what Congress had in mind. That might be a surprising result if your intuition is that a conservative court gets to conservative results, but it's the fact of the matter. And even just last week, Justice Thomas, who's of course one of the most conservative justices, joined the liberals in dissent in TransUnion versus Ramirez in a case where the majority cut back on standing rights for FCRA cases. And in dissent, Justice Thomas took the opposite position. So I point that out to say sometimes the intuition can be wrong about what conservative justices or judges will accept. And here, again, we have a court of purported textualists. And as Chris said, the textual case for this is actually quite strong. And so it's funny, in my conversations, I feel like when I talked to people who are in consumer finance, people who are in agencies, this theory feels like a little bit novel. When I talk to other lawyers, it feels less of a stretch to them. It feels more intuitively right. And that's because I think a lot of the arguments are, well, this isn't how Udap has been interpreted before. This is not the meaning of unfair as we've known it. We've never been expected to have compliance systems built out this way. And those arguments can be very persuasive in the regulatory context. They're actually a little bit harder to make in the judicial context, where courts just they haven't lived with that experience. And so, I think it's a good point. And any agency, if Commissioner Chopra went forward with this, I'm sure he'd be very strategic. It'd be a strong case or an insulated piece of guidance. And so he wouldn't be running the risk of putting disparate impact in the COA at risk by articulating this theory in this other context. So I think there's some possibility, actually, again, in terms of how it's articulated.
Thanks, Steve. And I kind of have a follow-up question to something that you just mentioned, but Ashok, I wanted to make sure you had a chance to chime in if you had anything to add there.
Sure. And I want to echo both Steve and Chris on this. I think the paper itself was excellent. I thought Chris's blog post responding was also really thoughtful and compelling as well. And I think one of the points that I think Chris raises that I think is important to think through is the sort of practical implications of, if there is a disparate impact theory under a UDAP statute, does that mean every grocery store or every other entity that's regulated is going to suddenly be subject to disparate impact analysis? And I think that's really worth thinking through carefully on the regulatory side. I think I have some degree of comfort in the fact that generally outside of either the consumer finance marketplace or the mortgage lending marketplace, outside of the world of financial products, pricing isn't so individualized that there comes this analysis as to what's causing disparities or questions over whether disparities are based on improper considerations or unnecessary considerations, in a way that, in a world of increasingly automated and technocratic decision making about consumer finance or other financial products, it's much more likely that you'll see disparities that are tricky and difficult to explain that will need to be tested through litigation. So I think I have a little bit less concern about that, but I do think it's really worth thinking carefully about before an agency tries to take the step.
I think that kind of led to the question I was going to follow up with you, Ashok. Steve kind of mentioned, again, we talked a lot about this as what the CFPB, what the CFPB can do as a regulator, even talking about public enforcement, but also thinking more about how critical private enforcement is to curbing discriminatory practices. So I was curious to hear all of you talk a little bit more about what you would like to see the Bureau do. One, what you would like to see the Bureau do or other regulators do to push this theory along. And then two, also, Ashok, if you could talk a little bit about from a private litigation perspective, what this would mean. So it's a bit of a question for all of you all, but also kind of bringing in a piece outside of the regulator.
Sure. So I'm happy to start, and Steve, I'm sure, would have great insight as well as a private litigator in this world as well. I think that it's a really interesting theory to test. I think it would be one that would benefit from agency action before private litigants really enter the space and try to make this law. I think Steve's points about this being a really strong textual case for extending Udap statutes into the discrimination world is really powerful, but I do think there could be some skepticism given sort of the historic approaches of various agencies and state AGs that have not considered this as part of the Udap world. I think there could be powerful signaling and powerful inertia that gets overcome if regulators were the first to act. But once, if the theory of liability gets accepted and there is sort of headway, whether that's through a formal rulemaking to explicitly make this part of a Udap statute, or through just creation of some precedent by filing either charges with HUD or having the CFPB itself initiate enforcement actions or even promulgate some informal guidance letters, I think that provides more direction to litigants and would give courts more comfort that this is intended to be within the statute's coverage.
Steve, Chris, would you all like to jump in with thoughts?
Well, I probably wouldn't comment on what I wish the CFPB would do on this issue. But what I would say is keeping things on the practical level. Steve's right that if this theory is going to work, the opportunity for a regulator to make it work is to find a really bad case of intentional discrimination in a non-credit product, let's say, and then say, well, this is unfair. Because then, that's the best opportunity to have a defendant that's not willing or able to defend itself against a theory like this. And so what does that mean practically from my side? Because I represent financial institutions. And so what I'll tell you is, like, a lot of my clients already would take the position that even if I have a deposit account, let's say, and there's no credit feature to it at all, so it's clearly not credit, they're still going to avoid intentional discrimination or something close that's a close proxy to it, because not just about the possibility of a Udap theory being applied to them, but there are other bad things that can happen to a financial institution when they do something like that. They have reputational risk. They have all kinds of other problems that they can get themselves into by behaving in that manner. And so as a practical matter, there's an incentive already for at least sophisticated financial institutions to not make themselves the easy target for this theory that Steve was talking about a moment ago. And so from a practical standpoint, that's where I am too. Who wants to be the low-hanging fruit that provides the opportunity for a motivated regulator to roll out a new theory at your own expense? And so people who are smart about this already are thinking that way, I'll tell you, even for a product that they don't consider covered by the Equal Credit Opportunity Act.
I think I agree with Chris there that two most likely areas are a strong case of disparate treatment, which frankly is most likely to happen for an entity that has not had years of compliance focused on discrimination in an area. That's where you'll find low-hanging fruit. So maybe it's possible. Probably likely in a lot of areas if you dug into it. The huge impact also is exactly what Chris said. If the agency took some position, even an informal one, that was insulated from judicial review, but it's just indicated in our supervisory and enforcement work, this is the position that we think is correct, that would have a huge market moving effect. So I think Chris is right. Chris is a good lawyer. His clients are doing this already to some extent. They could probably be doing it more, as my guess. In my experience, some entities do have coverage that's the same across, but many don't. And when they do, it's not identical. The robustness of it is not there. And so I think a public indication from the CFPB, even if it took no other action, could itself have a pretty big movement for institutions that have good compliance systems who focus on Udap now, and then would add on to that, will also look for discrimination issues. And some of them are obvious, like Chris said. I mean, the idea of looking and not using race as a segmentation outside of credit, institutions really don't want to do that. It gets more complicated with other protected classes. Maybe you'll start to see it sink in. As people start to think about disparate impact, maybe the alignment is not 100% there. So anyway, I think that that's right. That is an important signaling effect from the Bureau.
And just to take a step back, I know we talked a bit about disparate impact and talking about this Udap theory. So there was a really interesting footnote in the paper, and for those who are following along, I think it was a 78 if you want to check with the text, but it talks a lot about disparate impact discrimination, and particularly being more protective, and is insofar as it can stamp out discriminatory practices that that might survive a traditional test. And so, my apologies, Udap discrimination theory, as opposed to traditional tests, and how fitting neatly within those three elements of an unfairness claim. So could you walk us through this? And so really thinking about that third prong of an unfairness claim that requires that the injury not be outweighed by the benefits to the consumer, or competition, versus the second prong of a traditional disparate impact test that only requires the challenge practice is necessary to achieve legitimate business interest. Could you just walk us through that a little bit and what that might mean for the audience?
Sure, I'll try to walk through it in an understandable way. And I'm very interested in it. In my view, it might be largely academic right now for the reasons we just said. I don't think this is where an agency would start with. But essentially the argument is that under disparate impact, a business has to show that its challenge practice advances a legitimate business need. And arguably that's a pretty broad range of conduct that it could justify. And if a plaintiff can't show a less discriminatory alternative, then that's the end and the plaintiff loses. In unfairness, in contrast, once you've shown an unavoidable harm, the defendant could lose absent some showing that the harm is offset by benefits of the practice to consumers or competition. So essentially, there's likely some category of cases where a practice causes unavoidable harm. It advances a legitimate goal, like maybe meeting a return on investment. No less discriminatory alternatives exist that anyone can identify, but there are also not clear benefits of that practice to consumers or competition. So that's a case where the disparate impact case might lose, but the unfairness case might win, even though it's a discrimination case. I think that's plausible analytically, and there's probably facts where it works, but I think it'd be a very hard argument to advance to a court because you're already trying to convince them of this Udap theory. And instead of saying, here are decades of Supreme Court law and lower court case law and disparate impact from which you can draw and rely on, you're asking the court to essentially go out on a limb a little bit more and come up with some new standard. And in that case, you might actually be, instead of just overlapping with a COA, you might really be making a COA redundant. So it's very to overlap with each other and coexist. And here you might actually be saying, well, in fact, we don't need a COA. I think, again, it's plausible. You can imagine facts where it actually works out pretty well. But I would start with some of the easier cases or the guidance before moving there. I like the possibility, though. I think that it's interesting.
Thanks. And so, Chris, do you have anything to chime in or go to?
So like for me, the thing about disparate impact generally, as well as potentially under a Udap theory, that makes things very difficult is its unpredictability in application. Because my own view of how regulators apply disparate impact is there's the three elements that we all know. There's a disparate impact, there's a legitimate business justification, there's a less discriminatory alternative. But those don't seem to get applied in what I consider to be that uniform of a way. And in particular, sometimes a regulator will say, you know, I don't really think your legitimate business justification is legitimate, so I just disregard it as if it doesn't exist. And there have been a number of fair lending enforcement actions where that has happened. And likewise, what is the test for how closely the less discriminatory alternative has to serve that legitimate business alternative? That's been the subject of back and forth in the various versions of HUD's disparate impact rule, the most recent of which came out last week, you know, with varying degrees of strength of it must serve the interest equally well versus it must serve the interest. And so that lack of precision in disparate impact is already a problem because it creates an unclear set of rules of the road for businesses to follow. And so they don't know exactly what to do. And then I think if you expand it under Udap and particularly entertain the kind of argument that Steve was making a moment ago, which he identified as unlikely, but this different kind of unfairness disparate impact analysis, it becomes even less predictable. How do you know whether the benefits to competition outweigh the harm to some consumers? Think about credit scores, for example. Some consumers are harmed, others are benefited. Is it overall a good thing for society or not? And who's going to make that subjective judgment? So the lack of predictability is a real problem from my standpoint, not just because of fairness to businesses who have to try to comply with the law, but the deterrence of legitimate business activity that it results in when people don't know the rules and there's a heavy regulatory enforcement environment. Their default is just not to do anything. And so that's not necessarily great for the economy. So that's sort of my comment on the disparate impact angle of it.
Now, actually, maybe hearing Chris say that, reframe part of it. I don't disagree, but disparate impact itself has been relatively flexible. It's a principles-based regime, and part of the goal is for it to be flexible. So the same three steps can apply in employment and credit and housing, and they've worked pretty well when they've been applied there. And so when I think about application of this unfairness theory, we want to really identify what's the case that matters, that wouldn't be illegal under disparate impacts, it would be illegal under unfairness. And I think a lot of cases, really, if it's a practice that we really care about and we think a company could be doing better, we think it's discriminatory, there's probably enough flexibility in the disparate impact regime to actually target those practices. At least historically, again, when it's been applied correctly, I think it's worked pretty well.
And Ashok, did you want to chime in, or Chris, I saw you have your...
No, I'm going to wait to be...
Okay. I wanted to give everyone a chance before I move on. This is going to be in a similar vein, but again, just talking about the importance of what it means in signaling when we're thinking about Udap discrimination claims and the value there. And see, there's this one line in the article I'm talking about the fact that there's, I'll just read it. There's a crucial signaling and remediation value to treating civil rights violations as civil rights violations. Remedial and prospective policy responses that do not treat these abuses as civil rights issues will fall short of providing historically disadvantaged consumers, communities of color, adequate redress, and preventing for future exploitative practices. So I just love to hear if you can talk a little bit about that in the signaling value and in using this theory to have a more robust response to discrimination.
Sure. So the article presents two categories of types of cases. One is extending protections to practices that wouldn't otherwise be unfair, absent the discrimination. And that's an interesting, I mean, that's a whole new category of cases. And there's another category, which essentially the practices, you could already make an argument that it's unfair. So why are you going after it? If you think about a reverse redlining case, in reverse redlining, the two elements are you have a predatory or unfair practice, and it's targeted at minority communities. And for the agencies, many of those cases, they could just show the predatory unfair practice, show it's a UDAP, and stop the case there. It's an easier case to prove. You don't have to then prove the targeting. And I think, frankly, that's probably very compelling to some staff internally. They'll say, why make this extra step? One thought that I had as I was writing this paper is I get that. And I do think that there's a signaling effect. There's also, frankly, a fact development effect. So as plaintiff attorneys, we are oftentimes just litigating civil rights cases because we don't have a UDAP statute. We're not, Dodd-Frank Act is not available to us. And so we're looking for civil rights cases and we bring that claim. That frames how you develop the case as well. If a civil rights claim is part of your initial claim, that frames how you ask discovery questions, what types of questions you're asking, what types of documents you're looking for, how you're pushing employees or ex-employees, getting affidavits, those types of things. And frankly, what happens sometimes is you start with a case with some kernel of a discrimination issue there. Maybe it's just a disparate impact case, but because you're thinking about it through that frame, you start developing the evidence and you can uncover disparate treatment evidence, which frankly is not very unusual for us at all. Many of our best cases, we've gotten the strongest disparate treatment evidence through discovery because we're thinking about it as a civil rights case. And an agency who just approaches it as an unfairness case misses that opportunity. So it's signaling, but it's also, you are smoking out really what the key problem is in the case. And that's part of the agency's job. And I think if it doesn't do that, that's a miss from the agency's perspective.
And that's great. And Ashok, I saw you nodding along. I don't know if you had anything to add, or Chris, if you have anything in response to that.
I'll just echo what Steve was saying. I had a long time ago a coworker who always used to say that in the context of the Fair Housing Act, whenever there's a disparate impact claim, you can always smoke out evidence of intentional discrimination as well. And I think that that might be like a simplification of it, but I think Steve's point is a good one, that adding in the framework of discrimination to unfair practices investigations or unfair practices enforcement actions can often smoke out real meritorious discrimination issues.
So let me suggest an alternative. So let's say I'm the CFPB and I find an unfair practice that's targeted at a protected group of people. Why can't I say, I'm going to charge this as a UDAP case? It's unfair or abusive or whatever, but I'm going to tell the world that part of the element of the abusiveness or the unfairness was that it targeted people who were vulnerable because they are the members of a protected class. And why can't I also tell the world that I'm prioritizing this case because the impact is borne mostly by members of protected groups? So the Libre case, the one that was brought by the CFPB in March, I think it was March of this year, several months ago, sort of fits that bill very well. It wasn't brought as an ECOA case, it was brought as a UDAP case, but the CFPB was very publicly blunt about saying those were its motivations. And I've had very senior people from the CFPB say that will be our priority moving forward. When we find UDAP cases and the impacted community is a historically protected class, that one's going to the top of the list and we're bringing that case. That can also signal to the market not to target in an unfair or predatory way protected communities without having to do a stretch on what statute is involved. And of course, just as an aside, I'm still going to really be interested to see how doing a bail bond sort of arrangement in the Libre case is a consumer financial product or service. I'm staying tuned for that one because I think the CFPB is already taking a stretch in that case. Even if the facts of the case are really terrible, I don't know how that's a consumer financial product or service, but we'll see.
I'd love to see if Steve or Ashok want to respond before I move on. I feel like
I think it's great if the CFPB prioritizes cases that prey on historically disadvantaged protected classes. That's important. And Chris is interesting. I think maybe you even alluded to a different variation of the theory, which is part of the reason that it's abusive is it's preying on these classes. And that's sort of like not going completely where the article goes, incorporating this as an element maybe of what makes something abusive and looping it in more explicitly than just saying this is what we prioritize. I do think though that having that be part of your claim, once you get into the case, that frames the questions that you ask in discovery. And I think it does actually, if you're really focused on unfairness against everyone, and that's what the legal theory is specifically, then that's where your case is going to go. And so we'll see how that case like that develops where they prioritize it, maybe there's some lip service, but it's not part of the claim, it makes it harder to pursue. And I would say too, just so that we're clear, this is one category of these cases. This doesn't include the types of cases like that wouldn't otherwise be unfair because it's not inherently predatory. For example, to have different debt collection practices based on zip code or something. Really what makes that unfair is the discrimination piece of it.
And I think one additional point that strikes me is the fashioning of remedies at the end of the case. Once discrimination becomes formally part of a charge or a litigation, the remedies after the fact can more expressly address either racial discrimination or discrimination against other protected classes in a way that even the framing that you're talking about, Chris, which I think is a great one, to prioritize for standard Udap enforcement cases involving discrimination. I think if those do go to formal charging and litigation, if there's not an explicit discrimination allegation in there, it becomes harder to explain to a court or to anyone approving that settlement or judgment or whatever the remedy ends up being, why there needs to be either a race conscious or sex conscious remedy. So I think there's value beyond just the industry steering impact of the messaging.
I have a question for Chris. I don't know if I can inject, but when we think about this, Chris, as we talked about, there is a signaling effect for compliance programs. And it's not that hard to go to an entity that is both covered by a COA for some practices and not for other practices to say, well, just sort of make it uniform across. If you're thinking a lot about this for your credit products, and you're even thinking about it for deposit products that have credit elements, just take the extra step and make sure you're not going to discriminate in your deposit products even when there's not credit. And I'm thinking of, in your experience, have you come across the same types of, potentially over-compliance for entities where there's not really a strong argument that they're covered by these anti-discrimination laws at all in terms of the products and services that they're doing? If you have experience doing that, entities that in no part of their business provide credit, for example, and in no part of their business make housing unavailable, for example. Do you think that they also are thinking about anti-discrimination this way?
I think definitely not in the same way that a large sort of multi-line financial institution would be. So like, let's say I'm a bank and I have auto loans and personal loans and mortgage loans and deposit accounts. And so, as you said, very easy to say, well, I've already got all this fair lending compliance infrastructure built. I know I have all these fair lending experts running around my halls. Applying that same sort of discipline to my deposit products isn't that big of a deal. But if you think about a consumer financial services entity that doesn't lend, so let's say a consumer reporting agency, that's really probably one of the better examples, because even debt collectors, when they collect on behalf of a creditor, they themselves may not be subject to a COA because they're not the creditor, but the creditor still is. And a COA says it applies to all aspects of a credit transaction. And we've even seen enforcement activity on collections, like that consent order from the CFPB in 2013. So let's take a consumer reporting agency. So I don't represent the big consumer reporting agencies, but I represent some others. They are very focused on the Fair Credit Reporting Act. They're focused on accuracy and integrity. And their fair lending focus, to the extent they have it, is on the scoring side of their business to make sure that their model development doesn't incorporate variables that are problematic, like zip code, for example, or some other proxy for a protected characteristic. But let's leave the scoring piece apart. Let's just say you're a consumer reporting agency without scores. I don't think they're likely to apply a lot of discrimination analysis to that piece of their business. And the thing is, if they did, it would probably necessarily be disparate impact and not treatment, because their view is probably, look, I get a lot of information from data sources, furnishers, or wherever else I get it. I need to make sure it's accurate and that I then give it out to people who have a permissible purpose. That's what the FCRA tells me I have to do. I'm not intentionally doing anything based on anybody's race, gender, age, religion, sexual orientation, or whatever. And in fact, I don't even know. So I don't know what I would do to prevent myself from engaging in disparate treatment. But if you tell me that I have to do that in a disparate impact sensitive way, I don't know what to do. So I think you're right that there's not that mentality in some of those industries, but I think they wouldn't know what to do with it, actually.
And
Hopefully I answered your question.
Yeah, it's interesting. I think about the advice, when there's counter arguments, I think there's some reasonable possibility that we see some action in this space. It's one thing to tell an institution that has a compliance system, look, because this risk exists, extend it. I would take the same position with other institutions that are anywhere within like the core jurisdiction here, and to build those up based on what we see elsewhere. And I'm curious to know whether that would be the advice that you would give too, although it's a hard thing to ask.
Yeah, but I don't know what I would tell them. So like, take another example, like a payment processor. Okay. So a payment processor facilitates payments back and forth. Like if I want to PayPal you some money for like we split dinner or something, what will the payment processor do to avoid engaging in discrimination that might violate a Udap law? It's easy for them to avoid the disparate treatment. They could probably spot that and prevent it, the easy case, the opportunistic case. But then if you say to them, I want you to avoid disparate impact in the way you transmit money between consumers or between consumers and businesses, I don't know, I'm not sure what I would tell them actually to comply with that. So I'd have to do a lot of thinking about that seriously to figure out what compliance advice I would give them if I thought that were a realistic possibility for them. I would tell them all day long to avoid disparate treatment, because never should you not avoid that for tons of reasons. So that part of it isn't difficult to persuade anybody to do. And you would hope that any responsible business would avoid that at all times.
Yeah, it's interesting as I think about I think we're both in this, sometimes in this position, different contexts, but the idea of having disparate impact be this flexible principles-based regime doesn't strike me as too hard to say, let's go through some business policies. Are any of them likely to cause disparities? Truly, if you're treating everyone the same, or it's just random, the likelihood you're gonna have disparities is low. But once you start seeing segmentations, once you start seeing, well, we treat group A this way because, it's not too hard to say, well, is there an intuition that that treatment might fall disproportionately in a protected class? And then even if it doesn't, why are you doing these? What's the point of this? Start documenting those rationales, put those on paper to make sure they actually hold up. It seems like a good place to start.
And I would say that doing that kind of exercise is a good idea for UDAP purposes, even leaving discrimination aside. It's a good idea for your FCRA compliance. It's a good idea for lots of reasons to write down the rationale of why you do something and ask yourself, is it really achieving what you want with no collateral damage? Whether the collateral damage is based on protected characteristics or not. You could have collateral damage to consumers and it may not run along protected class lines and it still might be a UDAP violation, for example.
With that, I wanted to make sure, Steve and Shoki, didn't want to say anything else, but I know we're getting close to time. So I'll give you all just a second, just in case there's anything else you all wanted to add, but no, okay. Well, I just wanted to thank you all so much again for joining the panel. I was going to ask everyone if they could go around and give lasting thoughts, but again, we got into a really robust discussion, but that's awesome. But to Steve, Ashok, Chris, thank you all so much for this amazing conversation. And again, to Steve and Callie for this wonderful paper. So thank you all so much. If you all would like to just go around, if there are any last seconds, we have about a minute left before we end.
I'll just say, I just thank you guys for putting this on, and thank Chris and Ashok for engaging with the piece so thoughtfully. It's been fun to have the conversation. And the last piece is, ACOA, even as compared to Fair Housing Act, ACOA has sort of historically had some strange limitations in it. And I would say one part of this theory is some of those limitations really don't make sense. And this does help fill some of those gaps. That's probably where it's most likely to be used, I would think.
Ashok, you want to go next or shall I?
Sure. All I have to say is, I think, like I said, the paper is great. The response is great. I think it's always, treat to be part of conversations like this with great lawyers who are thinking through ways to extend and get at the root problems of discrimination and inequity. So thanks for having me.
Yeah, and I'll just say thank you as well. Thanks, Stephen Calley, for writing the paper. Thanks to Sbpc for putting me on the program. I'm looking forward to, like, I run into Steve a lot, so I'm going to get to talk to him about this a lot more times, and I'm looking forward to that as well. So I really do appreciate the interchange with both you and Ashok today. And Kat, thanks for moderating today's discussion.
Well, thank you all so much, and thanks so much for everyone for joining. Everyone have a great day. Thanks. Bye.